This is video number 2. Thank you for watching. Video 1, if you're watching them in sequence, which will be helpful, was about getting the court to suppress evidence by filing a motion to suppress. We went over search warrants, warrantless searches, and common scenarios. Once again, to recap, my name is Zachary Divelbiss. I am the owner of Future First Criminal Law and attorney. I am kind of jumping through some advice on challenging, hopefully successfully, in your case, drug possession charges that are brought up. So I'll go through real quick again. Like I said, went through the first set of options in the previous video. This video I'll go through the challenging of the prosecutor's evidence of the possession. So, the prosecution must prove beyond a reasonable doubt that the defendant possessed a controlled substance. This is, of course, the standard beyond reasonable doubt at any criminal trial. And getting into this is a lot of people have questions about, does the prosecutor, how are they going to prove this? What do they know? What do they don't know? What evidence do they have? And so hopefully this will kind of clarify some of the questions, especially surrounding some of the scenarios that we'll go through, because not a lot of people, see that it's fair. And whether you agree that it's fair or not fair, it's what the law is right now, and it's what we have to work with. The two types of possession, there's actual and then there's constructive possession, two different types. This is something that you kind of touch in law school when comparing different cases, and of course we see it in our everyday life in the actual cases that we have here in Arizona. The law recognizes two types of possession, actual and constructive. Actual possession means you have the drug on your person, hands, mouth, pocket, purse, backpack, stuffed in your, in your wallet, in your sock, whatever it is. Constructive possession means you do not have the drug on your person, but you have control over it. The example is Don purchased 7 hydrocodone pills illegally, placed them in his medicine cabinet from which he could retrieve them whenever he wanted. If the police find the pills in his medicine cabinet, Don could be charged with constructive possession of the pills, even though he did not have physical possession of them. It's a very easy scenario here that a lot of people find themselves trapped by. And this is, kind of the big way that innocent people can be found guilty, because there isn't much to it when it comes to constructive possession. This is kind of the argument of, drugs being found in the back seat of a car, in a trunk, and in you have roommates in somebody else's room at the house. Technically, you can be in possession of it, even though you weren't, within arm's reach of it. You knew you had access to it. Granted, there's more to it. Everybody's case is a little bit different, which is why it's important to hire a criminal lawyer to go through and assess your specific case. And this video is just meant to touch on the different things that lawyers consider, and hopefully you can see that and evaluate your case and then go to a professional to get the true final evaluation. Anyways, factors that indicate constructive possession are proximity and control. The totality of circumstances determines if a person constructively possessed an illegal substance. Proximity to the drug, that is how close you were to the drugs, how close were the drugs to the defendant, is one of the factors that the court considers. More specifically, it's what the prosecutor, it's what the police officers consider. Courts have consistently ruled that the proximity alone is not sufficient to convict a person of constructive possession of a controlled substance. We'll get into this more. Another important issue is whether the defendant had sole control of the area where the drugs were found. If multiple people are in an area, it can be difficult or impossible for the prosecution to prove which of them controlled any drugs that are found. This is kind of like I was saying, having roommates, having multiple people, having a common living area. Police will typically not do anything further that they probably should be doing, such as, they find a baggie of drugs. Well, they don't fingerprint the baggie. They can find, a pipe used to consume drugs, and they don't take any fingerprints of who actually had touched that pipe. They just will collect it, put it in evidence, and leave it at that. So it's very important that you recognize that there are minimal kind of standards, even though it sounds so simple of, well, they can't prove it. And that's what a trial is for. That's what any kind of evidentiary hearings are for, in order to evaluate this from either the judge or the jury. Example: Bob has a party at his house with several guests, a lot of drinking, a fight breaks out. The police are called and they find a bag of cocaine on the table. The cocaine could belong to anyone attending the party. June, a party guest, was sitting next to the table, but without additional evidence, it would probably be difficult for the prosecution to prove that she possessed the drugs or intended to possess the drugs. By contrast, if a person has sole possession of a house or a room, constructive possession is more easily proven. Keep in mind, especially in the party scenarios, the police come in essentially, in their authoritative figure, and they could theoretically charge everyone for it, because technically everybody was within proximity, everybody had control, and then it goes to the prosecutor as to whether the prosecutor believes that they've met it based on the actual constructive possession. So a lot of times, police will just charge it, and they overcharge it, and then they throw it to the prosecutors, and the prosecutors run with it. And it's not until a defense attorney steps in and actually puts their foot down to say that this is one that didn't cross the line, and that the prosecutor needs to reevaluate it. Anyways, next example: Bob lives alone, keeps to himself, and never has parties or guests. If the police found cocaine on the table in Bob's home, the prosecution will probably be able to prove that Bob knew about the cocaine and had constructive possession of it, because he has exclusive possession and control of the house. Seldom does anybody live so isolated from other people. Often 2 or more people reside in a house or apartment. This, once again, is kind of the rare situation, but it does happen. That there's only one person who lives there, or big things that help distinguish it is, if there's a separate lock on a door and the roommate doesn't have a key, then great, there's no way that the other roommate could have accessed that room. Of course, doors aren't locked at all times, different ways that people can get in. So it's definitely something to consider. The police will also look for identifying, for instance, in a bedroom, they'll look for things that show ownership of that room, such as mail that has your name on it, identifying, IDs, state IDs, things that have your name written on it. And those are basically all going to be brought in as evidence to say you knew the drugs were there, you had the sole possession, and nobody else did, which is why it's very important to challenge it and to hopefully be successful. Another example: Rick shares his home with 3 roommates. If cocaine is found in the house, Rick might be a suspect, but in most instances, the prosecution would have to provide additional evidence that Rick knew the cocaine was present and intended to maintain control over the drug. However, the prosecution would probably be able to prove constructive possession of the cocaine if it were found in a closet in Rick's room, which he always kept locked, to which he alone had the key. I jumped the gun on my example there. As you can see, even when the home has a single occupant, certain circumstances could indicate another person had control over the drugs. Just like I was explaining, they look for evidence that this person had the access to it and couldn't get it anywhere else. I know this is outside of what I'm talking about with drug possession, but this happens a lot for people who are prohibited possessors, and technically somebody, their spouse, somebody else living in the house, will have a firearm. Well, technically you have access to that firearm and you're in possession of it, and you could be charged with misconduct involving weapons. And it's I bring this example up because it's such a simple thing that people don't think of when it's that's my wife or my husband's gun, and really you're the one who's going to get in trouble for it if you're found out to be anywhere near it. Final example here: Ray's fiance frequently visits his home. Because Ray is the home's sole resident, a bag of cocaine on the coffee table would probably be sufficient evidence for the jury to conclude the drugs belonged to Ray. However, Ray could raise the defense that the drugs belonged to his fiancée, and he did not know the drugs were in the bag and had no intent to control them. The jury would then determine if they believed Ray. This is typically where the case ends up if it can't get dismissed beforehand and it ends up going to trial is you then present countering evidence that says, through testimony, through whatever evidence you can, specific enough but not incriminating enough to show that somebody else could have possessed the drugs. Either way, it also still just comes to the jury, and that's a very tough thing to sometimes roll the dice on, because every jury is a little different and there's no way to know ahead of time. Anyways, the innocent possession. So having an illegal drug in your immediate area or your possession does not automatically mean you have committed a crime. Most crimes have two aspects. A defendant must A, commit a bad act, and B, with the intent to do a bad act. So commit the act and have the intent. Intent's the key word here that we're looking at. The same is true with possession. A person may have possession of an illegal drug for an innocent reason. For example, fleeting possession can be a defense. Fleeting possession typically applies when a person takes possession of a drug to dispose of it. There's a California case that shows this point, and also the necessity of knowing that all the details before making a judgment. A neighbor saw Andy, the defendant, lean into the passenger side of a car, slap the passenger, take a red bandana from the car, and throw it into the field. Andy then drove off with the passenger still in the car. The neighbor called the police, and an officer found the bandana in the field. It contained heroin. No one disputed that heroin was in the bandana. No one disputed that Andy took the bandana from the passenger, and no one disputed Andy knew heroin was in the bandana. He was convicted of possession of heroin. Andy appealed his conviction. Here his motives became important. Andy observed the passenger was drowsy. He was concerned the passenger had overdosed and was losing consciousness. He slapped the passenger to revive him. He took the heroin from the passenger so he could not shoot up again. He drove the passenger to a fire department and explained the passenger needed oxygen. He was given oxygen transport to the hospital. Andy waited at the fire station for the police to arrive. So, Andy acted responsibly. He placed himself in legal jeopardy, though, to save someone else. He recognized the symptoms of his friend overdosing and acted promptly to get medical assistance for him. California ruled that Andy only held the drug long enough to dispose of it and did not constitute illegal possession of the heroin. Furthermore, the court noted that there's no evidence that Andy intended to resume control of the drug when he threw it into the field. He abandoned the property. If Andy had returned to the field to retrieve the drugs, the court probably would have come to a different conclusion. I know, there's a lot there, but this is a very good example of kind of the more or less perfect scenario, the perfect defense that you can have, and this doesn't happen a lot. And people, try and say, oh, well, I never really possessed it, or I got rid of it, or, I left it there. There typically needs to be a lot more than just, oh, I saw the drugs, I knew they were there, but I never went and got them. You have to commit the act of disposing of it, and that's the part that not a lot of people do or think to do. And it's still just so hard to prove, but that it's essentially the community caretaking aspect of it, of, look, I was doing the right thing. At the same time, you have to basically admit that you did possess the drugs. Either way, that's kind of why you definitely have to have a lawyer. That way you don't incriminate yourself, and the lawyer can speak on your behalf and present things in a more positive way than likely you could yourself. Anyways, Andy engaged in all the behavior that constitutes illegal possession. However, he did not intend to commit a crime. A New York court reached a similar conclusion when a bar's bouncer was arrested for possession of 14 packets of cocaine that he confiscated from a patron who was entering the bar. The bouncer's boss told him to confiscate the illegal drugs from anyone entering the bar, then deliver the drugs to the security agency that hired him. The security agency's policy was to turn the drugs over to the police. The New York court ruled that a person could have a legal excuse for possessing a legal drug. The bouncer was entitled to a jury instruction on innocent possession. The jury would then determine if the bouncer had the intent to maintain control of the drugs or had an innocent intent. Word of warning, these are state cases as well. State courts have different holdings and effects. Obviously, I'm here in Arizona, not in New York, not in California. Our laws don't always intercede. There is another video on kind of explaining how that works. But Arizona is like I was explaining earlier, they're very much charge first, ask questions later. So it's a lot of work in these situations. Anyways, next point here is disputing the possession. What seems like a simple element can be a big problem for the prosecution. Granted, the prosecution will have a relatively easy time proving possession if a defendant is found with a large amount of cocaine in his coat pocket. However, the prosecution often has to rely on constructive possession. Example, Anne leases an apartment but has a couple of roommates. Back to one of the examples I was explaining. Police find a marijuana plant on the windowsill. Anne is charged because the apartment is in her name. At trial, Anne's defense attorney cross-examines the arresting officer, asking him if he is aware that other people live in the apartment. The officer says yes. He added that only Anne's name was on the lease, so he arrested Anne. Questioning the officer about the other residents accomplishes two purposes. First, at least it will raise a doubt in the juror's mind concerning who owned the marijuana plant in the window. Second, mere proximity to drugs is insufficient to sustain a conviction. Therefore, the judge may dismiss the charges without a case going to the jury. However, since Anne is renting the apartment, the judge may still let the jury decide it. Once again, this is, the very intricate part of everything that I'm explaining is it's so case specific and every situation is a little different. And even if there is a law and there's a rule that says, a case must be dismissed, when it comes to the judge, they really get the deciding vote of whether they're just going to kind of let it continue or let it not continue. Of course, then you can appeal, which takes a lot more time. Typically, there's more costs in the private attorney world for appeals, and there's a lot to it. So it's something to think about, and which is why doing all this pre-trial is very important. Another example. Suppose instead that Beth was visiting Anne when the police came. Beth was sitting in a chair close to the window. Beth is charged with possession of marijuana, but the prosecution has no incriminating evidence other than Beth's proximity to the marijuana plant. In such a weak case, Beth's attorney would probably ask a few more questions at trial so that the witnesses are not inadvertently prompted to add a detail that would link Beth to the plant. At the close of the prosecution's case, the defense attorney would then ask the judge to dismiss the charge. There's a good chance the judge would do so. Frequently in drug cases, proximity is the most significant piece of evidence the prosecution can present. Once again, this is a very case-by-case scenario that judges have a lot of control and power over, and there's no guarantee that anything's going to go the right way. Just like these videos are to show different scenarios, and your scenario with one thing changed could lead to a completely different outcome. Example, Sam is well known by the police to be a crack addict. The police see Sam asleep or pass out in a back alley, and a crack pipe is lying within 3 feet of him. The pipe has sufficient crack residue that a person who had the pipe would be charged with possession of crack. There's a good chance that the police are going to arrest Sam. Here the problem with the case. Sam is not the only crack addict on the street. Also, there's no evidence other than proximity that links Sam to the crack pipe. This happens a lot. In Sam's case, the defense attorney may ask the police whether other people entered the back alley. The obvious answer is yes. He doesn't have the only possession of an alley. The defense attorney may ask other officers if they monitored their area before Sam was found to establish a crack pipe was not already on the pavement before he passed out. The police will probably answer no. Next, the attorney will ask, then you do not know if another person left the pipe on the street, do you? Great. If the judge does not dismiss the case against Sam's attorney can drive home the point that the prosecution has to prove his case beyond a reasonable doubt in closing argument. Jury may think the pipe already did belong to Sam because of his known addiction. However, the belief that the pipe probably belonged to Sam is not enough, and that should not be beyond a reasonable doubt. Anyways, beyond a reasonable doubt requires a higher level of certainty than probably. The prosecution may still try to allege the defendant constructively possessed a controlled substance in numerous situations. Assumptions of prejudice simply do not stand up when a defense attorney argues a case to a disinterested jury. What I'm saying here is basically there's so much of a gamble with a jury that if the jury has to decide, they may convict the client, the defendant, based on how the defendant looked that day at court, based on the fact that they believe, well, maybe this could have been their pipe. It's very hard to explain. Just like you're watching this video, you don't know everything about the law, and the jury knows even less. They're just there to kind of decide facts of the case, and putting your case in the jury's hands can be a very tough decision that you have to think out with your lawyer as to whether that is the best move that you are going to make. If you do, then great, and it could very well pay off in a very positive way. Once again, thank you for watching this. I know I've went through this fairly briefly, and there are so many other situations, cases, scenarios that you have. And if you have one, you should definitely contact me. That way we could set up a private consultation and we can go over some of the things that have happened and let you know how the outcomes could potentially look, what representing you would look like in order to get your case resolved.